What if I told you that your green card, the very document you worked so hard to obtain, could be taken away in an instant? Even if you followed every rule, paid your taxes on time, and built your entire life in America, there are 5 critical mistakes that could destroy everything you've worked for. And the scariest part is that most people don't even realize they're making these mistakes until it's too late. Stay with me because what you're about to learn could be the difference between keeping your American dream alive and losing it all in a matter of weeks. Welcome to World Discoverer Hub, your trusted source for critical immigration information that affects millions of people living legally in the United States. I'm here to guide you through the complex world of immigration law, and today's topic is one of the most important we've ever covered. We're talking about permanent residents, visa holders, and legal immigrants who are doing everything right or so they think but are unknowingly standing on the edge of a cliff. The immigration landscape has transformed dramatically, and what might have been overlooked just a few years ago can now trigger immediate deportation proceedings. This isn't about fear-mongering, this is about arming you with the knowledge you need to protect yourself, your family, and your future in this country. By the end of this video, you'll understand exactly which actions and situations pose the greatest threat to your legal status. More importantly, you'll know precisely what steps to take to safeguard your position and avoid the devastating consequences that have already impacted thousands of immigrants this year alone. So, if you or someone you care about holds a green card, work visa, or any form of legal status in the United States, this information is absolutely essential. Let's dive in. The first major threat to your legal status involves serious criminal convictions, and this is where things get particularly complicated. The term you need to understand is aggravated felonies. Now, here's where it gets confusing and dangerous. An aggravated felony under immigration law doesn't necessarily mean it was classified as a felony by your state court. Yes, you heard that right. Your state might have charged you with a misdemeanor. You might have paid a small fine, served no jail time whatsoever, and walked away thinking the matter was settled. But under federal immigration law, that same offense could be classified as an aggravated felony, and that classification changes everything. The federal immigration system operates under its own set of rules, and these rules are often far more severe than what you'll encounter in your local criminal court. Offenses that fall into this dangerous category include theft regardless of the amount stolen, fraud, even if it seems minor to you, assault, which can include situations where no physical injury occurred, and any form of violent behavior, including threats or intimidation. The critical factor here isn't how much time you spent in jail or whether you spent any time behind bars at all. The federal system looks at the nature of the crime itself and makes its own determination about severity. Let me paint you a picture of how this plays out in real life. Imagine you're a green card holder who's been living in the United States for 15 years. You own a home, your children were born here, and you've built a successful career. One night, you make a mistake. Maybe you get into an argument that turns physical. Maybe you're accused of taking something that doesn't belong to you. The local prosecutor offers you a deal: plead guilty to a misdemeanor, pay a fine, maybe complete some community service, and you can move on with your life. It seems like the smart choice. You want to put this behind you quickly. You don't want the expense and stress of a trial. So you accept the plea deal, pay your fine, complete your community service, and assume the chapter is closed. But here's the nightmare scenario. Months later, maybe even years later, you apply to renew your green card, or you travel outside the United States and attempt to return, or immigration authorities conduct a random review of your file. Suddenly, you receive a notice to appear before an immigration judge. That misdemeanor conviction you thought was behind you, immigration authorities have classified it as an aggravated felony. And once that happens, you're facing mandatory detention and almost certain deportation. There are very few defenses available. The judges have limited discretion. Your 15 years of lawful residence, your American children, your home, your career, none of it may be enough to save you. This is why the advice I'm about to give you is absolutely critical. If you are ever arrested, if you are ever charged with any crime, no matter how minor it seems, you need two attorneys, not one. You need a criminal defense attorney who understands the charges you're facing in state court. But just as importantly, you need an immigration attorney who can analyze those charges through the lens of federal immigration law. These two attorneys need to work together before you accept any plea deal, before you make any statements, before you take any action whatsoever. A decision that seems insignificant in criminal court can be catastrophic under immigration law. Don't let a moment of crisis destroy decades of lawful presence in this country. The second major threat involves drug charges, and this is an area where the law shows almost no mercy. Many people operate under the assumption that minor drug offenses, particularly possession of small amounts, won't seriously impact their immigration status. This assumption isn't just wrong, it's dangerously wrong. The reality is that drug convictions trigger some of the harshest consequences in all of immigration law.
Let's be very specific about what we're talking about here. Possession of cocaine regardless of the amount. Possession of heroin even in trace amounts. Possession of prescription medications that weren't prescribed to you, even if you're holding them for a friend or family member. Possession of methamphetamines, ecstasy, or virtually any other controlled substance. The amount doesn't matter. You could be caught with a single pill, a tiny residue in a bag, or a minuscule quantity in your pocket. Under immigration law, that's enough to initiate deportation proceedings. Now, there is one very narrow exception, and it applies only to marijuana. If you're charged with possession of marijuana, the amount is less than 30 grams, and this is your first offense, there's a possibility you might avoid immigration consequences. But notice how many conditions have to line up perfectly for this exception to apply. Less than 30 grams, roughly 1 ounce. First offense only, and no prior drug-related incidents. And even then, you're walking a tightrope because different jurisdictions interpret this exception differently. Here's another crucial point that catches people off guard. Let's say you're arrested on drug charges. You hire an attorney. You work out an arrangement. Maybe the prosecutor agrees to dismiss the charges if you complete a drug treatment program. Maybe you're offered a diversion program where the charges will be erased from your record if you stay clean for a certain period. You complete the program successfully. The charges are dismissed. Your criminal record shows no conviction. You breathe a sigh of relief and assume you're in the clear. But immigration authorities don't always see it that way. If at any point during the criminal proceedings you admitted to possessing the drugs, even if no conviction resulted, immigration officials can use that admission against you. That's right, an admission of guilt alone, even without a conviction, can be grounds for deportation. This is why you need specialized immigration advice the moment you're facing drug charges. What you say, what you admit to, how your case is resolved, every detail matters under immigration law in ways that aren't immediately obvious in criminal court. Think about the stakes here. You could be a permanent resident who's lived in the United States for 20 years. You could have children who are American citizens. You could own a business that employs dozens of people. But one mistake, one moment of poor judgment involving drugs can unravel everything. The immigration system doesn't care about your contributions. It doesn't care about your family ties. When it comes to drug offenses, the law is rigid and forgiving and brutally efficient. The third major threat involves family violence and domestic disputes, an area where immigration consequences are severe and far-reaching.
Any act of violence, threatening behavior, or violation of a protective order involving someone in your household can trigger deportation proceedings. And the definition of who counts as a household or family member is much broader than most people realize. We're talking about your current spouse, your ex-spouse, your children, including stepchildren and adopted children, your cohabiting partner, and your parents or in-laws who live with you. Essentially, anyone who shares your household or has a familial relationship with you falls under this umbrella. And the type of conduct that can get you in trouble is broader than you might think. Physical altercations are the obvious example. But it goes beyond physical violence. Unlawful touching, verbal threats, and violating a restraining order even unintentionally can all be classified as domestic violence under immigration law. Here's what makes this dangerous. In many jurisdictions, domestic violence charges are prosecuted as misdemeanors. You might not face jail time. You might be offered classes or counseling as part of a plea deal. The local prosecutor might frame it as a minor offense. But under federal immigration law, domestic violence offenses are treated with extreme severity. A misdemeanor domestic violence conviction can make you deportable regardless of how minor the incident was. Let me give you a real-world scenario. You're in a failing relationship. Emotions are high. During an argument, your partner calls the police. Maybe there was pushing. Maybe just raised voices. The police are on the side of caution and arrest someone. You're charged with domestic violence. A prosecutor offers you a deal, plead guilty to a misdemeanor, take classes, avoid jail, and move on. It seems reasonable, so you accept it. But here's what just happened. You've now been convicted of a deportable offense. Immigration authorities will see that conviction during a green card renewal, naturalization application, or even a random review. And unlike criminal court, immigration judges have very limited discretion. Your legal status, years of residence, and family ties in the United States, all of it is now in jeopardy because of one misdemeanor. This is why consulting an immigration attorney before accepting any plea deal in a domestic violence case is essential. The fourth major threat is immigration fraud, which can come back to haunt you years, even decades after an application. Immigration fraud includes lying on forms, using falsified documents, entering a fraudulent marriage, or misrepresenting facts in interviews. There's no statute of limitations on immigration fraud. If evidence surfaces years later, immigration officials can reopen your case, revoke your green card, and initiate deportation. This applies to every immigration benefit you've ever received. Marriage-based green cards, employment applications, asylum claims, and family petitions are all areas where fraud issues frequently arise. The key takeaway is that honesty isn't just the best policy, it's the only policy. Even small misrepresentations can be devastating when examined under federal law. If you've made mistakes on past applications, it's far better to consult an immigration attorney now than hope the issue never surfaces. The fifth threat might seem trivial, but involves a legal requirement. Green card holders and certain other legal residents must notify immigration authorities of any change of address within 10 days. Failing to do so is technically a violation. While authorities usually won't deport you solely for this, it can compound other issues and undermine your credibility. Updating your address is simple and should always be done promptly. Now let's talk about the broader context. Deportation proceedings are moving faster than ever. Cases that once took years may now be resolved in weeks. Judges are clearing backlogs quickly, meaning less time to prepare a defense. This is why prevention is critical. Once you're in immigration court, your options are limited. So, what should you do? First, if you ever face legal trouble, any interaction with law enforcement or criminal charges, consult an immigration attorney before making decisions. Second, maintain honest and accurate records with immigration authorities. Third, always update your address within 10 days. Fourth, keep comprehensive documentation of your life in the U.S. Fifth, stay informed about changes in immigration law. Sixth, if you have past mistakes or potential fraud issues, consult an attorney before proceedings begin. Finally, treat your legal status as an ongoing responsibility, not a one-time achievement. The current immigration environment is unforgiving. Criminal convictions, drug offenses, domestic violence charges, immigration fraud, and administrative violations can all lead to deportation. But knowledge is power. By understanding these risks and taking protective measures, you can significantly reduce your chances of facing serious consequences. Your legal status represents years of effort and sacrifice. It's worth protecting. Stay informed, stay compliant, and stay proactive. Here at US Visa Updates, we're committed to bringing you accurate and actionable immigration information. If this video helped you, please like and subscribe and share it with anyone who holds legal status in the US. Remember, this video provides general information, not personalized legal advice. If you're facing any of the situations discussed, consult a qualified immigration attorney. Your American dream is worth fighting for. Stay vigilant, stay informed, and stay safe. Until next time, this is World Discoverer Hub, keeping you informed about the immigration matters that affect your life. Thank you for watching, and we'll see you in the next.